this made national and international news. A white male father left his child inside of the car. 22-month-old Cooper died because of that man. The evidence was overwhelming. His conviction has now been overturned by the Georgia Supreme Court. Let me give you background to this case. Put up his picture with baby Cooper. This was one of those pictures made very famous during that infamous trial. Georgia's highest court on Wednesday overturned the murder and child cruelty convictions against a man whose toddler son had died after he was left in a hot car for hours, saying the jury saw evidence that was, and I quote, extremely unfair, extremely and unfairly prejudicial. Now, let's put up his mugshot, okay? I remember covering this case when it happened. It was gruesome, significant circumstantial evidence from what he Googled to his extramarital affairs and the fact he was in an inappropriate relationship with a child. But he also had a very strong church community that supported him during this trial, something that's not reported in the re-reporting of this story. The community stood by him with all of the evidence that he did in fact leave his child intentionally in that car. Now remember, he was convicted by a jury. Judge sentenced him. His name is Justin Ross Harris, was convicted in November of 2016 on 8 counts, including malice murder and the death of his 22-month-old son, Cooper. A judge sentenced him to life without parole, as well as 32 more years in prison for other crimes. I'm gonna get to that. Let me first bring you to the Chief Justice of Georgia. All right, that's your Chief Justice. The Chief Justice of Georgia issued a summary that said, hey, basically, there was enough evidence, yes, to convict him of the crimes. However, we just think some of the other evidence that was introduced was a bit much. I'm summarizing. All of the Supreme Court justices agreed that there was sufficient evidence to support the conviction. That's one dynamic. But the 134-page majority opinion written by the Chief Justice of Georgia says that much of the evidence having to do with Harris's sexual activities should not have been admitted and may have influenced the jury in an improper way. The ruling means that Harris is now entitled to a new trial on the murder and child cruelty charges against him. All right, this is interesting. This is really interesting. So all of the justices in Georgia agree, you actually do have enough evidence to support a conviction, meaning the fact finders of the case, being the jury, may actually not reach a different decision even without that additional information. I have seen courts actually say the judge or the court were in error by having this particular information. However, it would not have changed the outcome of the case, and they will allow the conviction to stand. I have seen many Supreme Court decisions just like that. There's more. The defense attorney for this monster says, we are very appreciative and grateful that we'll have a new trial, said Harris's attorney, Mitch Durham. The high court upheld Harris's convictions on 3 sex crimes committed against a 16-year-old girl that Harris had not appealed. Now, where did the 16-year-old girl come in at? During the course of their investigation of him killing his 22-month-old child, they found that he was in an inappropriate relationship with a 16-year-old girl, all right? He received a total of 12 years in prison for those crimes. The Cobb County DA's office plans to file a motion of consideration in the case, according to an email statement. So prosecutors argued, now think about the argument, this goes to your motive. Prosecutors argued that Harris was unhappy in his marriage and intentionally killed his son to free himself of it. To support this theory, they presented extensive evidence of extramarital sexual activities that he engaged in, including exchanging sexually explicit messages and graphic photos with women and girls and meeting some of them for sex. Defense attorneys described him as a doting father and said the boy's death was a tragic accident. The 6-3 majority opinion says the jury heard and saw an extensive amount of information. It was improperly admitted as evidence. Now, I actually agree with the dissent. Put up the justice who wrote for the dissent. I agree with the dissent in this case. That's Justice Charlie Bethel. Justice Bethel wrote a partial dissent that was joined by 2 other justices on the Georgia Supreme Court. He said the state was, and I quote, entitled to introduce in detail evidence of the nature, scope, and extent of the truly sinister motive it ascribed to Harris. For that reason, Bethel wrote, the trial court did not abuse its discretion in allowing the challenged evidence. Remember, the prosecution had a theory of the why. It's called your motive. And according to the prosecution, the motive was the fact that he had all of these entanglements, some even being illegal, that it became the catalyst for his criminal action. Now, let's be very clear. None of the justices believe this guy did not do this intentionally. They all believe that he killed his son. He not only had a background on the internet, basically researching how to get this done, he also had a lot of auxiliary dynamics connected to his behavior before and afterwards that suggested he was guilty. The jury, the fact finders, said guilty. The Supreme Court of Georgia says there's enough evidence to support him being guilty. But in a 6-3 ruling, they have now overturned that conviction. Fascinating. All right, Dina Dahl, you are a legal mind, an attorney, a legal analyst. What in the hell happened here?
This issue comes up all the time. Harvey Weinstein just tried to appeal his conviction for basically the same thing. You know, in our country, we can't convict people because they are bad people. We convict them because of the actual act they took, if that's a crime. And so there's always this tension between what the prosecutor wants to put in, showing prior bad acts that are either consistent with this crime or somehow, in this case, contribute to the motive of the crime, and the defendant never wants that to happen. And we see, convictions overturned because of this, and there is that balance. I think what happened here is because these prior bad acts were to do with having sex with underage girls, which is very offensive. Even if they were evidence of just affairs with people his own age, that could be considered a prior bad act. That probably would not have led to him being overturned. But because people are so offended about sex with underage girls, and the amount of evidence came in, that's, the court was talking about that. There was days of testimony. There was lots of lewd pictures. There were texts. I think the prosecution shouldn't have even introduced a lot of that. I think they could have made the point with one witness, maybe just 1 or 2 texts, they needed to do something to show motive, because people leave their children and pets in the cars. Like, this does kind of accidentally happen. But this wasn't a manslaughter charge. They were trying to say he intended for it to happen. So they had to do some of it. But I think that they should have reined themselves in and not done as much, because they did end up putting like this mini trial within the trial of, almost proving, the fact of him being basically a pedophile, which he was also convicted of. And I can see that having prejudiced the jury on the other conviction, unfortunately.
It is interesting because my law professor who taught me rules of evidence would say, a lot of this comes down to the discretion of the judge. And if the judge says, I do not believe this information is so prejudicial that it outweighs the probative value, and I'm going to make a judgment call. And typically when a judge makes a call like that and they weigh probative versus prejudicial, it's within their discretion. I was surprised that the Georgia Supreme Court basically said the judge was outside of his discretion by making this ruling to allow the evidence in. So going to be interesting to see what happens. Obviously, the prosecution, they do have the ability to retry this case now. I think what's going to happen, because this guy served a significant amount of time, they're going to offer him a plea deal. Do you agree that may be the way forward for him?
I think so, and in particular, because in that opinion, they said that there was not that much other evidence supporting this conviction, which if I were the prosecutor, I would read that and think my case is going to be weak if a lot of this is excluded.
All right, there you go. And we'll follow up. We'll make sure we follow this story for whatever happens next.